Search incident to lawful arrest. Police may search a lawfully arrested person and his immediate surrounding areas without a warrant. Requirements are 1, that the arrest be lawful, 2, that the search must be contemporaneous with the arrest, 3, that the search must be limited to the area within the suspect's reach or movement, or where he could obtain a weapon or destroy evidence. Protective sweeps. Police may sweep an area for officer safety or with reasonable belief that accomplices may be present. Inventory search. Police may search arrestees' belongings or seize property when jailing an arrested suspect. Automobiles. After arresting occupant, police may search the vehicle's interior, including the glove box, if at the time of the search, A, arrestee is unsecured and may access the vehicle's interior, or B, they reasonably believe evidence of the crime for which the arrest was made may be found in the vehicle. Police cannot search the trunk without probable cause or consent. Breathalyzer. A warrantless breathalyzer test is valid following a lawful arrest based on probable cause of drunk driving. Limitation. Cell phones. Police may not search digital information on a phone seized during an arrest without a warrant. Plain view searches. Police may search from any place where they legitimately present when viewing. Seizures based on plain view. Police may seize evidence in plain view without a warrant if 1, police are legitimately on the premises from which they viewed the evidence to be seized, 2, criminal activity or contraband is immediately apparent, and 3, police have probable cause to believe that plainly viewed evidence is contraband or relates to a crime. Scope of plain view searches includes anything viewable from land or public property, even if only viewable through binoculars. Plain smell is included within plain view. If a smell gives rise to probable cause from a place of legitimate police presence, they can search that item. Limitations. Police cannot use technology not generally available to the public to view evidence that may constitute plain view search, like infrared scanners that can view through walls. Note, the use of drones for plain view searches is unsettled law and thus unlikely to appear on the MBE. Consent to search. With valid consent, police may search anything. Requirements for valid consent. 1, voluntary and intelligently made. Police cannot falsely claim legal cause to search. Police have no obligation to inform suspects that they have a right to refuse consent. 2, person giving consent has authority to consent. Authority to consent must be reasonably apparent. Scope of consent can be limited by consenting party. Violation of scope renders the entire search non-consenting. Third-party consent is allowed if there is authority to consent, where multiple people have property rights, ownership, authorized use, occupancy. Any single one can consent to the search of any area where they have authority to consent. A resident's right to consent trumps a non-resident. So if both the tenant and the landlord are present, the tenant's refusal trumps the landlord's consent. Scope of the consent is dictated by the person present with the highest authority to consent. Refusal trumps consent. No consent if two persons with equal rights to possession disagree on consent. Automobile search exception. If probable cause exists, police may search an entire vehicle, including the trunk, and containers or compartments inside that may contain the evidence they are searching for. Requirements are 1, that police must have probable cause to search the vehicle, and 2, probable cause must rise before the search begins. Scope of permissible search. Police can search entire vehicle and all containers within the vehicle that might contain the object for which they are searching. For example, police may open packages or luggage that might contain evidence relating to the reason they searched the vehicle. Police may search passengers and their belongings. Stop and frisk. Police may detain a person for an investigative purpose if they have reasonable suspicion of criminal activity. Allowable scope of stop and frisk. Length. The detention must be no longer than necessary to verify the suspicion. Frisk. If police have reasonable suspicion the person is armed or dangerous, they may frisk for weapons. Plain feel. If police have reasonable belief during the frisk that what they feel is a weapon or contraband, they may seize the suspected item. Officers cannot manipulate the item to develop reasonable belief. It must be plain touch only. Evidence validly seized is admissible. Stop versus arrest. A stop is a brief detention, less than an arrest, but police may develop probable cause to arrest based on anything occurring or discovered during the stop and or frisk. Note, stop and frisk is often called a Terry type stop. If exigent circumstances exist, police can search or seize evidence without a warrant. Hot pursuit. And emergencies are a form of exigent circumstances justifying a warrantless search or seizure. Hot pursuit. While actively pursuing a fleeing felon, police can search for anything relating to the pursuit or can search for their own protection. Permissible scope is broad and reasonably necessary to prevent suspect from escaping arrest. Police can enter into a private dwelling after attempting an arrest in a public place if they have probable cause. Police can search or seize evidence that can disappear if police were required to secure a warrant. Drugs that may be discarded, DNA evidence that may not last, reasonableness judged by the totality of the circumstances. Emergency. Warrantless searches are justified for emergencies that threaten health or safety if not immediately acted upon. Police see someone injured or threatened with injury, bomb threats, need to find source of food or drug contamination. Whether an emergency exists is viewed objectively. Note, a valid plain view search can arise from any of the above warrantless searches.